Welcome. In this video, we're going to look at the effect of a defendant who declines to give evidence at trial. Shh. As you may know, a defendant has an absolute right to give evidence in his or her own defense. That is an essential tenet of a fair trial. A defendant also has the right not to give evidence at trial. This is an aspect of the right against self-incrimination. That being said, if a defendant declines to give evidence, certain consequences may follow. We're going to look at those consequences. Now, the starting point is the Criminal Justice and Public Order Act 1994, Section 35. Under this provision, a jury can draw adverse inferences from a defendant's failure to give evidence at trial. One of the inferences that a jury could draw is that the defendant is guilty of the offence of which he or she is accused. At the end of this video, we'll demonstrate how adverse inferences are dealt with in practice. Let's first look at the wording of Section 35. I suggest you pause the video and read the provision. Resume the video when you're ready. Okay, let's dissect Section 35. I'm going to focus on the defendant who refuses to go into the witness box to give evidence. It's clear from Section 35 that before an adverse inference can be drawn, there are certain conditions that must be satisfied. 1. The defendant's guilt must be an issue. 2. It must not appear to the judge that the physical or mental condition of the defendant makes it undesirable for the defendant to give evidence. 3. The trial judge must have satisfied him or herself in the presence of the jury that the defendant was aware that a. The stage had been reached at which evidence could be given for the defence. b. The defendant could, if he or she wished, give evidence. c. If the defendant chose not to give evidence, it would be permissible for the jury to draw such inferences as appear proper. And 4. The defendant declined to give evidence. Although judges have discretion when deciding whether to allow juries to draw inferences under Section 35, in the main, courts have been reluctant to exercise this discretion in favour of the defendant. In the case of Cowan, the court held that it will only be in exceptional cases that a jury should not be allowed to draw adverse inferences under Section 35. Let's turn to the question of how the court assesses whether or not a defendant has a mental or physical condition which would make it undesirable for him or her to give evidence. Firstly, expert evidence would normally be required to determine the defendant's mental and physical condition. Secondly, the court would have to be satisfied that it would be undesirable for the defendant to give evidence as a result of his or her mental or physical condition. It's clear from the case law on this issue that it will be very rare that a court will find the physical or mental condition of the defendant will make it undesirable for the defendant to give evidence. However, an example of where the Court of Appeal did hold that a Section 35 direction to the jury would be inappropriate is the case of Friend No. 2. The Court of Appeal in this case concluded that due to the defendant's ADHD, cognitive deficits, anxiety, and verbal intellectual deficits, it was undesirable for him to give evidence. Let's consider the nature of the adverse inference that can be drawn under Section 35. If the evidence against the accused calls for an explanation by the defendant, which the defendant ought to be in a position to give, then we know that a failure to give any explanation may allow the drawing of an inference. The inference will be that the defendant has no explanation to give, and that the accused is guilty. Now, let's see how adverse inferences work in practice. Your Honour, that is the close of the prosecution case.
Thank you, Mr. Barnes. Mrs. Hill, have you advised your client that the stage has now been reached at which he may give evidence, and if he chooses not to do so, or having been sworn, or having affirmed, without good cause refuses to answer any question, the jury may draw such inferences as appear proper from his failure to do so.
I have, Your Honour.
All right, thank you. Members of the jury. Mr. Warner chose not to give evidence. That is his right, but it has these consequences. Firstly, he has not given evidence in the trial to contradict or undermine the evidence of the prosecution witnesses, Mr. Glynn, the store detective, Mr. Singh, the store manager, and Mr. Fields, the cashier. Mr. Warner did give an account to the police, which his advocate has told you he stands by. That interview is part of the evidence, but it was not given on oath and tested in cross-examination. Secondly, you will remember that when I asked Mr. Warner's advocate whether Mr. Warner was going to give evidence, she told us that he understood that if he failed to do so, you, members of the jury, would be entitled to draw inferences from that failure. In other words, that you would be entitled to conclude that Mr. Warner did not feel he had an answer to the prosecution case that would stand up to cross-examination. You must decide whether or not Mr. Warner's failure to give evidence should count against him. First, you must be sure that the prosecution case is so strong that it calls for an answer. Second, you must be sure that the true reason for not giving evidence is that he did not have an answer that he believed would stand up to questioning. You must remember it is for the prosecution to prove the guilt of the defendant, and while Mr. Warner's failure to give evidence can provide support for the case, you cannot convict the defendant wholly or mainly because of that failure.
You can now understand when an adverse inference can be drawn following a defendant's refusal to give evidence. See you next time.